Today, we already reported on the murder charge, but now there are 5 more charges. This court document filed just this week in my hands lays out the defense's argument for why bond consideration should be granted to the 31-year-old pregnant mom. The motion argues that the responsibility to prove the case lies entirely with prosecutors. The defense says the state has not met that burden, pointing out that Johnson has no prior criminal history. She had a license to carry a firearm. Still, let's go through some of the pages of this document. The first few pages outlines why Johnson is claiming self-defense, saying she was protecting herself and her 6-month-old child that was in the car when Blackmon, quote, ran up and swung. According to the filing, Blackmon repeatedly threatened Johnson through phone calls and text messages. The threats escalated to the point that Blackmon allegedly told Johnson's grandmother she intended to kill her. At the time, Johnson was pregnant and, according to her attorney, feared for her life and the safety of her unborn child. They also say an order of protection was granted months before the shooting, though we found one that was never delivered. Now, on the morning of the shooting, that was September 8th last year, Johnson was being driven back to her car by her child's father when Blackmon unexpectedly arrived. She had just dropped off her son in that area. Both women have children by the same man. The motion claims Blackmon allegedly blocked Johnson's vehicle, approached her aggressively and said, "I told y'all I was going to catch you."
Months after a mother was gunned down outside her child's school, the courtroom has once again become the center of a case that continues to divide public opinion. While justice delayed does not always mean justice denied, for the family of Romeca Blackmon, every court appearance reopens a painful wound that has yet to heal. The judge overseeing this case is far from finished, and neither is the public conversation surrounding it. Stay with me until the end, and let me know your thoughts in the comments. Do you believe this case is moving toward a full trial? Or could it take a different direction? If you have been following the Romeca Blackmon case, then you already know it has sparked outrage, debate, and countless unanswered questions since day one. Yesterday, Quadia Holly Johnson appeared in court once again, and today the hearing continues. Before we dive deeper, make sure you like this video, subscribe to the channel, and share it so others can stay informed. Here is a brief recap of what has unfolded so far. In September 2025, Romeca Blackmon was shot and killed outside her child's school in Chicago shortly after drop-off. On the same day, the alleged shooter, Quadia Holly Johnson, was taken into custody but was not immediately charged, which triggered widespread public outrage. In the weeks that followed, video footage and witness accounts circulated online, fueling intense debate over claims of self-defense. As pressure mounted, Romeca's family and members of the community demanded accountability and transparency from prosecutors. Later in 2025, Johnson was formally charged with first-degree murder and ordered to remain in custody following a detention hearing. By January 2026, the case entered ongoing pre-trial and status hearings, with both the defense and prosecution preparing their arguments. Yesterday, Johnson appeared in court again as the judge reviewed the progress of the case. Before we continue, I want to hear from you. We do not take sides here, we stand for justice. This case has drawn attention from multiple states across the country, and from people who believe in accountability. I will now share a video from Tia Ewing highlighting the January 7th court hearing. Listen closely and tell me what stood out to you. I want to begin by making something very clear. What I am about to share are the facts as they have been presented in court filings. When I say facts, I am referring to what has been officially filed and documented, not opinions, rumors, or internet speculation. Some of what appears in these filings includes allegations, and it is important to understand what that word truly means. Allegations represent someone's version of events or their narrative of what they claim occurred. Allegations are not proven facts unless, and until they are supported by evidence and upheld through the court process. To explain this more clearly, someone can claim that they were hit by a car, but if video evidence later shows that the incident never happened, the claim alone does not make it true. People can say many things, but the facts must ultimately stand on their own. In this case, my focus is on what has been formally filed with the court. Whether everything contained in those filings is ultimately proven to be true remains to be seen, and that determination will be made by the legal system, not by public opinion. The document I am referencing is a court filing that was officially submitted on Monday, January 5th, at 3:58 p.m., as confirmed by its timestamp. This filing was submitted by the defense attorney representing Quadia Holly Johnson. I want to be transparent that I will not be sharing the document publicly, nor will I be naming witnesses or identifying individuals who are not public figures. There are serious safety concerns involved in this case, and I believe certain information deserves to be protected. I have received multiple emails from people expressing concern that witnesses in this case have been threatened or intimidated. Some have raised alarms about the safety of individuals who are expected to testify. Because of that, I will not engage in naming or identifying witnesses. Whatever a witness claims to have seen or heard is their narrative, and it is not the public's job to harass, intimidate, or attempt to influence them. That responsibility belongs to the court. The legal process must be allowed to unfold without interference. The filing itself spans approximately 20 pages, and condensing that amount of information into a short news segment or summary is extremely challenging. To help make sense of it, I broke the document down into 8 sections or slides for clarity. While I did not present all 8 publicly, I highlighted the portions that stood out as particularly significant. What I am going to do now is walk you through those highlighted sections, focusing on the arguments presented by Quadia Holly Johnson's attorney. One of the first major points raised in the filing appears on page 3. The defense argues that since Ms. Johnson's last detention hearing, her legal team has had the opportunity to speak with her family, review discovery materials, and gain a deeper understanding of both the case and Ms. Johnson's personal background. According to the filing, this newly obtained information represents a change in circumstances significant enough to justify a reconsideration of Ms. Johnson's detention status. The defense further argues that the court initially relied solely on allegations when determining Ms. Johnson's custody status. They contend that the state has failed to meet its burden of proving, by clear and convincing evidence, that the proof is evident and the presumption is great that Ms. Johnson committed the offense. In simpler terms, the defense claims the evidence does not strongly support continued detention under the standards required by law. Additionally, the filing argues that the circumstances and facts of the case do not support the conclusion that Ms. Johnson poses a real and present threat to the safety of any person. This argument directly challenges the factors courts typically consider when deciding whether a defendant should remain in custody prior to trial. Another critical portion of the filing focuses on the legal standard for establishing self-defense. According to the defense, to claim self-defense, a defendant must show evidence that unlawful force was threatened against them, that the danger was imminent, that the defendant was not the aggressor, and that they genuinely believed force was necessary to prevent harm. Furthermore, the force used must be reasonable and proportional to the perceived threat. The defense supports this argument by citing precedent from previous cases, which they believe applies to Ms. Johnson's situation. The document goes on to criticize how the state and media coverage have portrayed the case. According to the defense, reporting has sensationalized the incident, while failing to capture what they describe as the full reality of events. The filing claims that the victim repeatedly threatened Ms. Johnson, her family members, and her close friends through various means, including persistent phone calls and text messages. The defense alleges that these threats were relentless and escalated over time. According to the filing, Ms. Johnson was forced to block the victim's phone number due to the volume and severity of the threats. The defense further claims that the victim went so far as to locate Ms. Johnson's grandmother's phone number and allegedly made threats indicating an intent to kill Ms. Johnson. These claims, it is important to emphasize, are allegations presented by the defense and have not yet been adjudicated. Another significant element raised in the filing concerns an order of protection. According to the defense, an order of protection against the victim was sought in December 2024 and granted in July 2025, several months before the fatal incident. The defense asserts that the victim was served with the order and was fully aware of its existence. The defense also references a transcript from a June 18, 2025 hearing related to that order of protection. According to the filing, the transcript demonstrates what the defense characterizes as the victim's aggressive behavior, not only toward Ms. Johnson but also toward the court. The defense claims that the court repeatedly instructed the victim to stop speaking, and that her behavior undermined her own position during the hearing. Based on this information, the defense argues that Ms. Johnson clearly demonstrated that unlawful force had been threatened against her, and that she reasonably believed she was in imminent danger. They assert that her actions were taken in response to that perceived threat. The filing then moves into a detailed account of the events that took place on the morning of September 8, 2025. According to the defense, Ms. Johnson had spent the weekend at the residence of her 6-month-old child's father, Carlos Smith. That morning, the two drove together in Smith's black Mercedes to the location where Ms. Johnson's vehicle was parked. Surveillance footage from the school reportedly shows the victim entering the school building with her child at approximately 8:51 a.m. and exiting at 8:53 a.m. Around 8:56 a.m., Smith's vehicle is seen entering the street from an alleyway and double parking several car lengths in front of Ms. Johnson's vehicle. As Ms. Johnson transferred her child from Smith's vehicle to her own car, additional footage captured a white Kia sedan making a U-turn and parking in a manner that blocked Ms. Johnson's vehicle. According to the filing, the victim owned that Kia. The defense claims that neither Ms. Johnson nor Mr. Smith invited the victim to the scene. Instead, the victim allegedly approached them unsolicited, yelling statements such as, "I told y'all I was going to catch you." This account is reportedly supported by a witness statement and body camera footage referenced in the filing. According to the defense, an argument followed, during which Ms. Johnson allegedly pleaded with the victim to leave her alone. While this was reportedly the first in-person encounter between the two, the defense argues that the history of prior threats made the situation immediately frightening for Ms. Johnson. The defense asserts that Ms. Johnson reasonably believed she and her child were in danger, and that the use of force was necessary to prevent harm. They further argue that the state improperly relied on uncorroborated witness statements that are inconsistent and unsupported by video evidence. According to the filing, there is no video footage that directly captures the shooting itself. The defense notes that footage from nearby cameras and a school bus did not record the actual moment of the shooting. They also argue that multiple witnesses provided inconsistent accounts, and that none observed the full sequence of events. One witness, according to the filing, was wearing large noise-canceling headphones at the time of the incident. The defense questions how accurately that witness could have heard what was happening, especially when other witnesses without headphones also struggled to hear clearly. The defense argues that all evidence presented by the state is circumstantial and insufficient to meet the legal burden required to justify continued detention. As a result, they request that Ms. Johnson be released from pretrial detention. The filing also highlights Ms. Johnson's background, noting that she was preparing to begin dental school and operated a successful lash business. The defense emphasizes that she has no history of violent criminal behavior, has been steadily employed, and has contributed positively to her community. Additionally, Ms. Johnson reportedly received a Level 3 score on her public safety assessment, a designation that does not recommend detention under Illinois' pretrial system. The defense argues that alternatives such as electronic monitoring or home detention would be appropriate and sufficient to ensure compliance with court conditions. To be clear, my role here is not to determine guilt or innocence. That is the responsibility of the court. My goal is simply to present what has been filed and explain what the defense is arguing at this stage of the case. This motion was filed pursuant to Illinois Supreme Court Rule 604, which allows a defendant to seek relief from pretrial detention under specific circumstances. According to the defense, the evidence does not prove beyond a reasonable doubt that Ms. Johnson committed the offenses she has been charged with, which now total 6 charges. Some exhibits referenced in the filing were not available to me, so I cannot comment on their contents. However, based on what has been presented, the case will continue with further court proceedings scheduled for 9 a.m. the following day. As this case moves forward, the legal system continues to weigh the evidence while a family grieves a loss that can never be undone. All eyes remain on what the judge will decide next. Do you believe the evidence supports the charges? Or do you think this case could take a different turn? Share your thoughts respectfully.